Lesson 3 Issue and Allotment of Securities Issue and Allotment of Securities. Learning Objective 61 For raising the capital from the public, through issue of securities, listed companies have to comply with the provisions of Companies Act, 2013, the Securities Contract, Regulation, Act 1956, SEBI, ICDR, Regulation, 2009, other relevant regulations of SEBI, Listing Obligations and Disclosure Requirements, Regulations, 2015, Stock Exchanges, etc. The unlisted companies have to comply with the provisions of Companies Act 2013 and the relevant rules made thereunder. Issue of shares on preferential basis, issue of bonus shares, issue and redemption of preference shares, employee stock option. After going through this lesson, students will be able to understand procedural aspects for issue of securities through various modes including private placement, rights issue, bonus issue, issue of shares at premium, issue of sweat equity shares, issue of shares under employee stock option scheme, regulated by SEBI, share-based employee benefits, regulations, 2014, etc. And also procedural aspects relating to allotment, issue of share certificates, forfeiture and buyback of securities. The details relating to issue of securities by listed company can be referred in the study Secretarial Audit, Due Diligence and Compliance Management. Broad Regulatory Framework, a revisit. Chapter 3 of the Companies Act, 2013 deals with prospectus and allotment of securities. This chapter is divided into two parts. Part I deals with public offer and Part 2 deals with private placement. Public offer includes initial public offer or further public offer of securities to the public by a company, or an offer for sale of securities to the public by an existing shareholder, through issue of a prospectus. Explanation to Section 23. Private placement means offer of securities or invitation to subscribe securities to a selected group of persons by a company, other than by way of public offer, through issue of a private placement offer letter and which satisfies the conditions specified in Section 42 of the Companies Act, 2013. Explanation 2 to Section 42-2, Provisions relating to issue of securities, Section 23, Issue of securities by a public company. A public company may issue securities, a. to public through prospectus, public offer, by complying with the provisions of Part I of Chapter 3 of the Act, or, b. through private placement by complying with the provisions of Part 2 of Chapter 3 of the Act, or, c. through a rights issue or bonus issue in accordance with the provisions of this Act and in case of a listed company or a company which intends to get its securities listed also with the provisions of the SEBI Act, 1992 and the rules and regulations made thereunder. In the case of a public company, which is a listed entity or is desirous of listing its securities on a recognized stock exchange in India, the issue of securities is governed by the Companies Act, Securities Contract Regulation Act, 1956, the SEBI Act, 1992 and the issue of capital and disclosure requirements, regulations, 2009. Issue of securities by a private company. For a private company, the section provides that a private company may issue securities, a. by way of rights issue or bonus issue in accordance with the provisions of this Act, or, b. through private placement by complying with the provisions of Part 2 Chapter 3 of the Act. In the case of all issues by private companies, the same is governed by the Companies Act, 2013 and the power of administration is exercised by the central government, the tribunal or the registrar of companies as the case may be. Dematerialization. Section 29 of the Act provides that every company making public offer of any security, shall issue the securities only in dematerialized form by complying with the provisions of Depositories Act, 1996 and the regulations made thereunder. According to Rule 9 of Companies, Prospectus and Allotment of Securities, Rules, 2014 made under Chapter 3 of the Act, the promoters of every public company making a public offer of any convertible securities may hold such securities only in dematerialized form. the entire holding of convertible securities of the company by the promoters held in physical form up to the date of the initial public offer shall be converted into dematerialized form before such offer is made, and thereafter such promoter shareholding shall be held in dematerialized form only. Let us understand certain terms. Securities 63 Securities has been defined under Section 281 to mean the securities as defined in Clause H of Section 2 of the Securities Contracts, Regulation, Act, 1956. The relevant section says that securities include H. Securities include I. Shares, scrips, stocks, bonds, debentures, debenture stock or other marketable securities of a like nature and or of any incorporated company or other body corporate, IA, derivative, IB, units or any other instrument issued by any collective investment scheme to the investors in such schemes, IC, security receipt as defined in Clause ZG of Section 2 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002, ID, units or any other such instrument issued to the investors under any mutual fund scheme. Explanation. For the removal of doubts, it is hereby declared that securities shall not include any unit-linked insurance policy or scrips or any such instrument or unit, by whatever name called, which provides a combined benefit risk on the life of the persons and investment by such persons and issued by an insurer referred to in Clause 9 of Section 2 of the Insurance Act, 1938, 4 of 1938, any certificate or instrument, by whatever name called, issued to an investor by any issuer being a special purpose distinct entity which possesses any debt or receivable, including mortgage debt, assigned to such entity, and acknowledging beneficial interest of such investor in such debt or receivable, including mortgage debt, as the case may be. 2. Government securities, II. Such other instruments as may be declared by the central government to be securities, and 3. Rights or interest in securities. Prospectus in general parlance. Prospectus refers to an information booklet or offer document on the basis of which an investor invests in the securities of an issuer company. The prospectus has been defined under Section 270 so as to mean any document described or issued as a prospectus and includes a red herring prospectus referred to in Section 32 or shelf prospectus referred to in Section 31 or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. Red herring prospectus under explanation to Section 32 has been defined as a prospectus which does not include complete particulars of the quantum or price of the securities included therein. In simple terms, a red herring prospectus contains most of the information pertaining to the company's operations and prospects, but does not include key details of the issue such as its price and the number of shares offered. A red herring prospectus shall carry the same obligations as are applicable to a prospectus, and any variation between the red herring prospectus and a prospectus shall be highlighted as variations in the prospectus. Shelf prospectus under explanation to Section 31 has been defined as a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of a further prospectus. In simple terms, shelf prospectus is a single prospectus for multiple public issuer. Is permitted to offer and sell securities to the public without a separate prospectus for each act of offering for a certain period. Such prospectus is to be submitted at the stage of the first offer of securities, which shall indicate a period not exceeding 1 year as the period of validity of such prospectus. The validity period shall commence from the date of opening of the first offer of securities under that prospectus, and in respect of a second or subsequent offer of such securities issued during the period of validity of that prospectus, no further prospectus is required. Deemed prospectus according to Section 25(1) of the Companies Act, 2013, when a company allots or agrees to allot any securities of the company with a view to all or any of those securities being offered for sale to the public, any document by which the offer for sale to the public is made, shall, for all purposes, be deemed to be a prospectus issued by the company. Section 25(2) provides that unless the contrary is proved, it shall be the evidence that an allotment of, or an agreement to allot, securities was made with a view to securities being offered for sale to the public if it is shown, a. that an offer of securities or of any of them for sale to the public was made within 6 months after the allotment or agreement to allot, or, b. that at the date when the offer was made, the whole consideration to be received by the company in respect of the securities had not been received by it. Abridged prospectus. According to Section 2(1) of the Act, abridged prospectus means a memorandum containing such salient features of a prospectus as may be specified by the Securities and Exchange Board by making regulations in this behalf. Section 33 of the Act provides that no form of application for the purchase of any of the securities of a company shall be issued unless such form is accompanied by an abridged prospectus. The procedural checklist with respect to issue of securities through public offer and various issues by listed company are dealt in detail in the paper Secretarial Audit, Compliance Management and Due Diligence, in Lesson of Issue of Securities. Private placement. Under the private placement, the offer of securities or invitation to subscribe securities shall be made to such number of persons not exceeding 50 or such higher number as may be prescribed, excluding qualified institutional buyers, and employees of the company being offered securities under a scheme of employee stock option, in a financial year and on such conditions as may be specified under Rule 14(2) of Companies, Prospectus and Allotment of Securities, Rules, 2014. Rule 14(2) prescribes that such offer or invitation shall be made to not more than 200 persons in aggregate in a financial year. Private placement to be treated as public offer. According to Section 42(4), any offer or invitation not in compliance with the provisions of Section 42 shall be treated as public offer, and all provisions of this Act, and Securities Contracts, Regulation, Act, 1956 and the Securities and Exchange Board of India Act, 1992 shall require to be complied with. Offer made only to specified persons. Section 42(7) states that private placement shall be made only to such persons whose names are recorded by the company prior to the invitation to subscribe, and that such person shall receive the offer by name, and that a complete record of such offers shall be kept by the company in such manner as may be prescribed, and complete information about such offer shall be filed with the registrar within a period of 30 days of circulation of the relevant private placement offer letter. Allotment of securities. 65. According to subsection 6 of Section 42, the company shall allot its securities within 60 days from the date of receipt of application money. If it does not allot within 60 days, then the application money shall be repaid within 15 days after the expiry of 60 days, and if company does not pay money after the aforesaid period, the company is liable to repay the money with interest at 12% per annum from the expiry of 60 days. Monies to be kept in separate bank account. The monies received shall be kept in separate bank account with a scheduled bank and shall not be utilized for any purpose other than a. for adjustment against allotment of securities, b. for the repayment of monies where the company is unable to allot securities. Exemption to NBFC and HFC. Sub-Rule 5 of Rule 14 of the Companies, Prospectus and Allotment of Securities, Rules, 2014 provides that the criteria of offer or invitation to 200 persons in aggregate in a financial year and minimum investment size of 20,000 rupees of face value shall not be applicable to non-banking financial companies registered with the Reserve Bank of India and housing finance companies registered with the National Housing Bank, if they are complying with the regulations made by RBI or NHB in respect of offer or invitation to be issued on private placement basis. Procedure to make allotment through private placement. 1. Hold the board meeting and pass board resolution for convening the meeting of members and approving draft notice of meeting of members. 2. Hold the general meeting and pass the special resolution. 3. Send letter of offer in Form PA.4 along with application form to the proposed subscribers, whose names are recorded by the company prior to the invitation. Subscribe. 4. File Form MGT.14 along with the fees as provided in the company's Registration of Offices and Fees, Rules, 2014, with the registrar within 30 days of passing the resolution. 5. The explanatory statement annexed to the notice for the general meeting required US 102 shall disclose the basis or justification for the price, including premium, if any, at which the offer or invitation is being made. 6. If the said offer or invitation is for non-convertible debentures, it shall be sufficient if the company has passed a previous special resolution during year for all the offers or invitation for such debentures. 7. The offer or invitation shall not be made to not more than 200 persons in the aggregate in a financial year excluding KIBs and employees offered securities under ZOP. 8. The value of such offer or invitation per person shall be with an investment size of not less than 20,000 rupees of face value of the securities. 9. All monies payable towards subscription of securities under this section shall be paid through check or demand draft or other banking channels but not by cash. 10. The payment to be made for subscription to securities shall be made from the bank account of the person subscribing to such securities, and the company shall keep the record of the bank account from where such payments for subscriptions have been received and the monies payable on subscription to securities to be held by joint holders shall be paid from the bank account of the person whose name appears first in the application. 11. The company shall maintain a complete record of private placement offers in Form PA 5. 12. File Form PA 5 along with the private placement offer letter in Form PA 4 with the registrar with fee as provided in Companies, Registration Offices and Fees, Rules, 2014, and where the company is listed, with the Securities and Exchange Board within a period of 30 days of circulation of the private placement offer letter. 13. A return of allotment of securities under Section 42 shall be filed with the registrar within 30 days of allotment in Form PA 3 and with a fee as provided in the Companies, Registration Offices and Fees, Rules, 2014, along with a complete list of all security holders containing I. The full name, address, permanent account number and email ID of such security holder. 2. The class of security held. 3. The date of allotment of security. 4. The number of securities held, nominal value and amount paid on such securities, and particulars of consideration received if the securities were issued for consideration other than cash. 14. Issue share certificates and update minutes book and registers. 15. Company shall intimate the details of allotment of securities to depository immediately on allotment of such shares. Note, explanation I to Section 42, 2, read along with Section 42, 4, provides that any offer or invitation not in compliance with provisions of this section shall be treated as public offer, and all the provisions of this Act, and the Securities Contracts, Regulation Act, 1956 and the SEBI Act, 1992 shall be required to comply fault with. Equity shares with differential voting right. An equity share with differential rights is like an ordinary equity share, but it provides fewer voting rights to the shareholder. The difference in the voting rights can be achieved by reducing the degree of voting power. Companies issue equity share with differential rights for prevention of a hostile takeover and dilution of voting rights. It also helps strategic investors who do not want control, but are looking at a reasonably big investment in a company. Section 43 provides that the share capital of a company limited by shares shall have two kinds, namely, a. Equity share capital, I, with voting rights, or, 2, with differential rights as to dividend, voting or otherwise in accordance with such rules as may be prescribed. B. Preference share capital. Rule 4 of the Companies, Share Capital and Debentures, Rules, 2014 provides that no company limited by shares shall issue equity shares with differential rights as to dividend, voting or otherwise, unless it complies with the conditions mentioned in this rules. Procedure for issue of equity shares with differential voting rights. 1. Check whether the Articles of Association of the company authorizes issue of equity shares with differential rights, and if not, then amend the Articles of Association of the company. 2. Hold the board meeting to issue the notice of general meeting for issuance of equity share with differential rights along with the explanatory statement US 102 of the Act. 3. Before issuing equity shares with differential rights as to dividend, voting or otherwise, ensure the following. I. The shares with differential rights shall not exceed 26% of the total post-issue paid-up equity share capital including equity shares with differential rights issued at any point of time. 2. The company has consistent track record of distributable profits for the last 3 years. 3. The company has not defaulted in filing financial statements and annual returns for 3 financial years immediately preceding the financial year in which it is decided to issue such shares. 4. The company has no subsisting default in the payment of a declared dividend to its shareholders or repayment of its matured deposits or redemption of its preference shares or debentures that have become due for redemption or payment of interest on such deposits or debentures or payment of dividend. V. The company has not defaulted in payment of the dividend on preference shares or repayment of any term loan from a public financial institution or state-level financial institution or scheduled bank that has become repayable or interest payable thereon or dues with respect to statutory payments relating to its employees to any authority or default in crediting the amount in Investor Education and Protection Fund to the central government. 5. The company has not been penalized by court or tribunal during the last 3 years of any offense under the Reserve Bank of India Act, 1934, the Securities and Exchange Board of India Act, 1992, the Securities Contracts Regulation Act, 1956, the Foreign Exchange Management Act, 1999 or any other special act, under which such companies being regulated by sectoral regulators. 4. If the company is listed with any of the recognized stock exchange, then within 15 minutes of the closure of the aforesaid board meeting intimate to the concerned stock exchange about the decision taken at the board meeting. 5. Pass the ordinary resolution in the general meeting. 6. If the company is listed or if the number of members are more than 200, then ensure it obtains the approval of its shareholders through postal ballot as per Rule 22 of the Companies, Management and Administration, Rules, 2014. 7. Once the company makes any allotment, then it shall, within 30 days thereafter, file with the registrar a return allotment in Form PA3, along with the fees as specified in the Companies, Registration Offices and Fees, Rules, 2014. 8. The company shall not convert its existing equity share capital with voting rights into equity share capital carrying differential voting rights and vice versa. 9. In case of listed company, send copies of the notice and a copy of the proceedings of the general meeting to the stock exchange within 24 hours of the occurrence of event. Regulation 36 of SEBI Listing Obligations and Disclosure Requirements, 2015, 10. Complete all other proceedings for the issue of certificate of shares with differential voting rights, making necessary entries in various registers. In case of a company whose shares are dematerialized form, inform the depositories about the same for credit to the respective accounts. 11. Intimate the details of allotment of shares to the depository immediately on allotment of such shares. 12. Maintain the register of members under Section 88 containing all the relevant particulars of the shares so issued along with details of the shareholders. Issue of shares at discount. Section 53 of the Companies Act, 2013, prohibits a company to issue shares at discount except in the case of issue of sweat equity shares. Any shares issued by a company at a discounted price shall be void. Where a company contravenes the provisions of Section 53, the company shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees, and every officer in default shall be punishable with imprisonment for a term of which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees, or with both. Issue of sweat equity shares. According to Section 288 of the Companies Act, 2013, sweat equity shares means such equity shares issued by a company to its directors or employees at a discount or for consideration, other than cash, for their providing know-how or making available rights in the nature of intellectual property rights or value additions, by whatever name called. Sweat equity shares are different from shares issued by a company under Employee Stock Option Scheme, ESOS, and Employee Stock Purchase Scheme, ESPS. The rights, limitations, restrictions and provisions applicable to equity shares shall be applicable to sweat equity shares, and holders of such shares shall rank pari passu with other equity shareholders. Conditions for issuance of sweat equity shares. Section 54 provides that, A company may issue sweat equity shares of a class of shares already issued, if the following conditions are fulfilled, namely, a. The issue is authorized by a special resolution passed by the company, b. The resolution specifies the number of shares, the current market price, consideration, if any, and the class or classes of directors or employees to whom such equity shares are to be issued, c. Not less than 1 year has, at the date of such issue, elapsed since the date on which the company had commenced business, and d. Where the equity shares of the company are listed on a recognized stock exchange, the sweat equity shares are issued in accordance with the regulations made by SEBI in this behalf, and if they are not so listed, the sweat equity shares are issued in accordance with such rules made under the Chapter 4 of the Companies Act, 2013. Procedure for issue sweat equity shares. 1. Convene board meeting to approve the notice of general meeting. 2. Issue notices in writing or through electronic mode, at least clear 21 days before the date of meeting along with the explanatory statement as required US 102. 3. The explanatory statement to be annexed to notice and the resolution for approving the sweat equity shall inter alia contain the following information: a. The date of the board meeting at which the proposal for issue of sweat equity shares was approved, b. The reasons or justification for the issue, c. The class of shares under which sweat equity shares are intended to be issued, d. The total number of shares to be issued as sweat equity, e. The class or classes of directors or employees to whom such equity shares are to be issued, f. The principal terms and conditions on which sweat equity shares are to be issued, including basis of valuation, g. The time period of association of such person with the company, h. The names of the directors or employees to whom the sweat equity shares will be issued and their relationship with the promoter or, and key managerial personnel, i. The price at which the sweat equity shares are proposed to be issued, j. The consideration including consideration other than cash, if any to be received for the sweat equity, k. The ceiling on managerial remuneration, if any, be breached by issuance of such sweat equity and how it is proposed to be dealt with, l. A statement to the effect that the company shall conform to the applicable accounting standards, and, m. Diluted earnings per share pursuant to the issue of sweat equity shares, calculated in accordance with the applicable accounting standards. 4. A copy of gist along with critical elements of the valuation report shall be sent to the shareholders with the notice of the general meeting. 5. Hold the general meeting and pass the special resolution. 6. The special resolution authorizing the issue of sweat equity shares shall be valid for making the allotment within a period of not more than 12 months from the date of passing of the special resolution. 7. File the special resolution with the concerned ROC with explanatory statement in Form Management 14 along with the fees as provided in Companies, Registration of Offices and Fees, Rules, 2014 within 30 days of passing of the special resolution. 8. If the shares of the company are listed with the stock exchange, then forward copies of the notice and a copy of the proceedings of the general meeting. 9. If the shares are listed with any of the recognized stock exchange, then issue of the sweat equity shares shall be in accordance with SEBI, Issue of Sweat Equity, Regulations, 2002. 10. Once the allotment is made, the company shall within 30 days of allotment, file with the registrar a return of allotment in Form PA.3, along with the fee as specified in Companies, Registration of Offices and Fees, Rules, 2014. 11. The company shall maintain a register of sweat equity shares in Form SH.3 at the registered office or such other place as the board may direct. The entries in the register shall be authenticated by the company secretary of the company or by any other person authorized by the board for the purpose. 12. Deliver the share certificates of allotted shares within a period of 2 months from the date of allotment. 13. Intimate the details of allotment of shares to the depository immediately on allotment of such shares. Issue of shares at a premium. The word premium implies something more than normal. With reference to shares and securities issued by a company, premium means a sum over and above the face or par value of a security. It is the amount which is excess of the issue price of a share over its face value, or par value, and is referred to as share premium. When shares are issued by a company at a price above their face value, or par value, then the shares are said to have been issued at a premium. It is the difference between the price at which a company issues a share and the face value of a share. Application of Securities Premium Account. Section 52 of the Companies Act, 2013 deals with the application of premium received on issue of shares. In accordance with subsection 1 of Section 52, where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount or value of the premium on those shares shall be transferred to an account, to be called Securities Premium Account, and the provisions of this act relating to reduction of share capital of a company shall, except as provided in this section, apply as if the Securities Premium Account were the paid-up share capital of the company. The Securities Premium Account may be applied by the company, a. towards the issue of unissued shares of the company to the members of the company as fully paid bonus shares, b. in writing off the preliminary expenses of the company, c. in writing off the expenses of, or the commission paid or discount allowed on, any issue of shares or debentures of the company, d. in providing for the premium payable on the redemption of any redeemable preference shares or of any debentures of the company, or, e. for the purchase of its own shares or other securities under Section 68. Subsection 3 of Section 52 provides that the Securities Premium Account may be applied by such class of companies as may be prescribed and whose financial statement comply with the accounting standards prescribed for such class of companies under Section 133, a. in paying up unissued equity shares of the company to be issued to members of the company as fully paid bonus shares, or, b. in writing off the expenses of or the commission paid or discount allowed on any issue of equity shares of the company, or, c. for the purchase of its own shares or other securities under Section 68. Further issue of shares capital. Section 62 of the Companies Act contains provisions relating to further issue of share capital through, a. rights issue of shares, Section 62 1a, b. issue of shares through employee stock option, Section 62 1b, c. issue of shares on preferential basis, Section 62 1c, rights issue of shares. Section 62 1 states that at any time, a company having a share capital proposes to increase its subscribed capital by the issue of further shares, such shares shall be offered, a. to persons who, at the date of the offer, are holders of equity shares of the company in proportion, as nearly as circumstances admit, to the paid-up share capital on those shares by sending a letter of offer subject to the following conditions, namely, I. the offer shall be made by notice specifying the number of shares offered and limiting a time not being less than 15 days and not exceeding 30 days from the date of the offer within which the offer, if not accepted, shall be deemed to have been declined. However, in case of private companies, in case 90% of members have given their consent in writing or in electronic mode, the lesser period than the specified period shall apply. 2. Unless the articles of the company otherwise provide, the offer aforesaid shall be deemed to include a right exercisable by the person concerned to renounce the shares offered to him or any of them in favor of any other person, and the notice referred to in clause I shall contain a statement of this right. 3. After the expiry of the time specified in the notice aforesaid, or on receipt of earlier intimation from the person to whom such notice is given that he declines to accept the shares offered, the Board of Directors may dispose of them in such manner which is not disadvantageous to the shareholders and the company. Procedure for issue of rights shares. I. Check whether the rights issue results in increase of authorized capital. 2. If so, call a board meeting to approve the notice of general meeting to pass necessary special resolutions. SD. The general meeting to amend memorandum, articles of association. 3. Convene the general meeting and obtain shareholders' approval through special resolution. 4. The offer should be made by notice, specifying the number of shares offered and limiting a time not being less than 15 days and not exceeding 30 days from the date of the offer within which the offer, if not accepted, shall be deemed to have been declined. This notice shall be dispatched through registered post or speed post or through electronic mode to all the existing shareholders at least 3 days before the opening of the issue. However, in case of private companies, in case 90% of members have given their consent in writing or in electronic mode, the lesser period than the specified period shall apply. V. Check the copy of Form SH7, MGT 14 filed with ROC. Phi. The shares declined by the existing shareholder can be disposed of by the company in manner which is not disadvantageous to the shareholders and the company. 7. Once the allotment is made, the company shall within 30 days of allotment, file with the registrar a return of allotment in Form PA.3, along with the fee as specified in Companies, Registration of Offices and Fees, Rules, 2014. 8. Deliver the share certificates of allotted shares within a period of 2 months from the date of allotment. 9. Intimate the details of allotment of shares to the depository immediately on allotment of such shares employee stock option as per Section 62(1) (b) of Companies Act 2013. The company can offer shares through employee stock option to their employees through special resolution subject to the conditions specified under Rule 12 of Companies, Share Capital and Debentures, Rules 2014, for the purposes of Clause B of subsection 1 of Section 62, and this rule employee means, a permanent employee of the company who has been working in India or outside India, or b. a director of the company, whether a whole-time director or not but excluding an independent director, or c. an employee as defined in clauses a or b of a subsidiary, in India or outside India, or of a holding company of the company. But does not include, I. an employee who is a promoter or a person belonging to the promoter group, or 2. a director who either himself or through his relative or through anybody corporate, directly or indirectly, holds more than 10% of the outstanding equity shares of the company. Procedure for issue of securities to employees through employee stock option scheme. 1. Convene a board meeting to approve the notice of a general meeting along with special resolution, explanatory statement, etc., to be approved by the shareholders through special resolution. In case of private company, it is sufficient that they obtain ordinary resolution. 2. The company shall make the following disclosures in the explanatory statement annexed to the notice for passing of the resolution: A. The total number of stock options to be granted. B. Identification of classes of employees entitled to participate in the employee stock option scheme. C. The appraisal process for determining the eligibility of employees to the employee stock option scheme. D. The requirements of vesting and period of vesting. E. The maximum period within which the options shall be vested. F. The exercise price or the formula for arriving at the same. G. The exercise period and process of exercise. H. The lock-in period, if any. I. The maximum number of options to be granted per employee and in aggregate. J. The method which the company shall use to value its options. K. The conditions under which option vested in employees may elapse, for example in case of termination of employment for misconduct. L. The specified time period within which the employee shall exercise the vested options in the event of a proposed termination of employment or resignation of employee, and M. A statement to the effect that the company shall comply with the applicable accounting standards. Ensure that the special resolution is filled with ROC in MGT 14 within 30 days of passing the resolution. 3. The company's granting option to its employees pursuant to employee stock option scheme will have the freedom to determine the exercise price in conformity with the applicable accounting policies, if any. 4. The approval of shareholders by way of separate resolution shall be obtained by the company in case of a grant of option to employees of subsidiary or holding company, or, b. Grant of option to identified employees, during any 1 year, equal to or exceeding 1% of the issued capital, excluding outstanding warrants and conversions, of the company at the time of grant of option. 5. A. The company may by special resolution, vary the terms of employees' stock option scheme not yet exercised by the employees provided such variation is not prejudicial to the interests of the option holders. B. The notice for passing special resolution for variation of terms of employees' stock option scheme shall disclose full of the variation, the rationale therefor, and the details of the employees who are beneficiaries of such variation. 6a. There shall be a minimum period of 1 year between the grant of options and vesting of option. Provided that in a case where options are granted by a company under its employees' stock option scheme, in lieu of options held by the same person under an employee's stock option scheme in another company, which has merged or amalgamated with the first mentioned company, the period during which the options granted by the merging or amalgamating company were held by him shall be adjusted against the minimum vesting period required under this clause. b. The company shall have the freedom to specify the lock-in period for the shares issued pursuant to exercise of option. c. The employees shall not have right to receive any dividend or to vote or in any manner enjoy the benefits of a shareholder in respect of option granted to them, till shares are issued on exercise of option. 7. The amount, if any, payable by the employees, at the time of grant of option may be forfeited by the company if the option is not exercised by the employees within the exercise period, or, b. The amount may be refunded to the employees if the options are not vested due to non-fulfillment of conditions relating to vesting of option as per the employee's stock option scheme. 8a. The option granted to employees shall not be transferable to any other person. b. The option granted to the employees shall not be pledged, hypothecated, mortgaged or otherwise encumbered or alienated in any other manner. c. Subject to clause d. No person other than the employees to whom the option is granted shall be entitled to exercise the option. d. In the event of the death of employee while in employment, all the options granted to him till such date shall vest in the legal heirs or nominees of the deceased employee. e. In case the employee suffers a permanent incapacity while in employment, all the options granted to him as on the date of permanent incapacitation, shall vest in him on that day. f. In the event of resignation or termination of employment, all options not vested in the employee as on that day shall expire. However, the employee can exercise the options granted to him which are vested within the period specified in this behalf, subject to the terms and conditions under the scheme granting such options as approved by the board. 9. The board of directors shall, inter alia, disclose in the director's report for the year, the following details of the employee's stock option scheme: a. Options granted, b. Options vested, c. Options exercised, d. The total number of shares arising as a result of exercise of option, e. Options lapsed, f. The exercise price, g. Variation of terms of options, h. Money realized by exercise of options, i. Total number of options in force, j. Employee-wise details of options granted to, i. Key managerial personnel. 2. Any other employee who receives a grant of options in any 1 year of option amounting to 5% or more of options granted during that year. 3. Identified employees who were granted option, during any 1 year, equal to or exceeding 1% of the issued capital, excluding outstanding warrants and conversions, of the company at the time of grant. 10a. The company shall maintain a register of employee stock options in Form No. sh.6 and shall forthwith enter therein the particulars of option granted under Clause B, of subsection 1, of Section 62. b. The register of employee stock options shall be maintained at the registered office of the company or such other place as the board may decide. c. The entries in the register shall be authenticated by the company secretary of the company or by any other person authorized by the board for the purpose. 11. Once the allotment is made, the company shall within 30 days of allotment, file with the registrar a return of allotment in Form PA.3, along with a fee as specified in Companies, Registration of Offices and Fees, Rules, 2014. 12. Deliver the share certificates of allotted shares within a period of 2 months from the date of allotment. 13. Intimate the details of allotment of shares to the depository immediately on allotment of such shares. 14. Where the equity shares of the company are listed on a recognized stock exchange, the employee's stock option scheme shall be issued, in accordance with the regulations made by the Securities and Exchange Board of India in this behalf. Issue of shares on preferential basis. Section 62(1)(c) of the Companies Act 2013 read with Rule 13 of Companies, Share Capital and Debentures, Rules 2014 enables issue of shares to persons other than the existing shareholders, employees as specified in Section 62(1)(a) and Section 62(1)(b, provided if the same is approved by special resolution and subject to the conditions stated in the said Rule 13. Procedure for issue of shares on preferential basis. A. Check whether the issue is authorized by articles. If not, make necessary amendments to alter the articles of association, through special resolution passed at the shareholders' meeting. B. Convene a board meeting to approve the notice of general meeting and necessary special resolution, along with explanatory statements as required. It is to be noted that preferential issue of share are required to comply with Section 42 also, which relates to private placement. However, in case of preferential offer to one or more existing members, the aspects relating to letter offer as stated in Rule 14(1) and proviso to Rule 14(3) of Companies, Prospectus and Allotment of Securities, Rules, 2014 shall not apply. C. The company shall make the following disclosures in the explanatory statement to be annexed to the notice of the general meeting pursuant to Section 102 of the Act. I. The objects of the issue. 2. The total number of shares or other securities to be issued. 3. The price or price band at, within which the allotment is proposed. 4. Basis on which the price has been arrived at along with report of the registered valuer. Relevant date with reference to which the price has been arrived at. 5. The class or classes of persons to whom the allotment is proposed to be made. 7. Intention of promoters, directors or key managerial personnel to subscribe to the offer. 8. The proposed time within which the allotment shall be completed. 9. The names of the proposed allottees and the percentage of post-preferential offer capital that may be held by them. X. The change in control, if any, in the company that would occur consequent to the preferential offer. 11. The number of persons to whom allotment on preferential basis have already been made during the year, in terms of number of securities as well as price. 12. The justification for the allotment proposed to be made for consideration other than cash together with valuation report of the registered valuer. 13. The pre-issue and post-issue shareholding pattern of the company in the prescribed format. D. Convene general meeting and pass necessary special resolution. S. E. Ensure to file Form MGT14 with Registrar of Companies within 30 days of passing the resolution. F. The securities allotted by way of preferential offer shall be made fully paid up at the time of their allotment. G. The allotment of securities on a preferential basis made pursuant to the special